In the realm of data protection, conducting a data protection impact assessment, DPIA, is a pivotal process outlined under the General Data Protection Regulation, GDPR, for ensuring privacy and compliance. The guidelines, revised and adopted by the Article 29 Data Protection Working Party on October 4, 2017, offer comprehensive insights into when and how a DPIA should be conducted. This video delves into the essence of these guidelines, their scope, and their implications for data controllers and processors. The birth of DPIA guidelines. Originating under Directive 95/46/EC and further emphasized in GDPR Article 35, the DPIA is a process designed to evaluate the risks associated with processing personal data. It assesses the necessity and proportionality of processing operations and identifies measures to mitigate risks to the rights and freedoms of individuals. The guidelines provide a structured approach to conducting a DPIA, ensuring that data processing activities are aligned with the GDPR's requirements. When is a DPIA required? A DPIA is mandated when processing activities are likely to result in a high risk to the rights and freedoms of natural persons. This encompasses situations involving extensive data processing, such as systematic monitoring, processing sensitive data on a large scale, or employing new technologies. The guidelines further elaborate on specific scenarios and criteria to help determine the necessity of a DPIA, ensuring clarity for data controllers. Key steps for conducting a DPIA. The guidelines outline a systematic procedure for carrying out a DPIA, which includes systematic description, detailing the processing operations, their purposes, and the data protection risks involved. Necessity and proportionality assessment, evaluating whether the data processing is essential for the stated purpose and if it infringes on the data subject's rights. Risk assessment, identifying and assessing the risks to individuals' rights and freedoms, considering both the likelihood and severity of potential harm. Mitigation measures, determining measures to address identified risks and ensure GDPR compliance. DPIA methodology and involvement. The methodology for conducting a DPIA can vary but must adhere to the criteria set by the GDPR. It involves seeking advice from the Data Protection Officer, DPO, and, where appropriate, consulting with data subjects or their representatives. The process emphasizes transparency, accountability, and the active participation of all stakeholders involved in data processing activities. The impact and recommendations. The DPIA guidelines serve as a critical tool for data controllers and processors to navigate the complexities of GDPR compliance. They foster a culture of privacy and data protection by design, encouraging organizations to proactively assess and mitigate privacy risks. By adhering to these guidelines, organizations can enhance trust with data subjects and avoid potential fines and reputational damage resulting from non-compliance. Conclusion. The DPIA guidelines by the Article 29 Data Protection Working Party are instrumental in guiding organizations through the intricacies of GDPR compliance. They underscore the importance of assessing, managing, and mitigating risks associated with data processing activities. As the digital landscape continues to evolve, these guidelines will remain a cornerstone for ensuring privacy and protection in the processing of personal data.